are diving deep today into, well, a really fascinating legal fight, shaking up Hollywood, especially around reboots and maybe shows that feel a bit familiar.
That's right. Imagine this. A huge hit show. The Pitt. Gritty medical drama, wins 5 Emmys, the big one included. Everyone's talking about it.
A massive success story.
Until it hits this legal wall. A major lawsuit from the estate of Michael Crichton. Yes, the creator of ER.
Okay.
And the claim, it's pretty bold. They're saying the Pitt isn't new at all. It's basically ER in disguise, an unauthorized reboot.
Right. Let's try and unpack that straight away because, Warner Bros., the studio, they own the ER episodes, the scripts, the copyright. So how can Crichton's estate possibly sue to stop them making something, well, something like it?
That is absolutely the core question here, and the answer, it lies in something pretty powerful and honestly quite rare these days in contracts. It's called the frozen rights clause.
Frozen rights.
Exactly. Crichton negotiated this into his original ER deal. It's basically ironclad. It says point blank. No sequels, no remakes, no spin-offs, no derivative works based on ER without his consent, or now his estate's consent, period.
Wow. So even if the studio owns the copyright to the specific episodes, the specific expression, Crichton, through this contract clause, kept control over the future, over the brand itself.
Precisely. Control. That's the magic word. Standard copyright gives the studio a lot, absolutely.
Yeah.
But this frozen rights clause, it's a contractual veto, a really strong one.
So our goal today, for you listening, is to really dig into that difference, the difference between having contractual control, like these frozen rights, versus just standard copyright. And where's that line between a show that's inspired by something and one that's actually an unauthorized copy?
It's a crucial distinction. This case is a perfect storm illustrating it. A real case study for anyone creating or producing content.
Okay, let's start with the contract claim itself. Seems like the most straightforward path, at least initially. We know Crichton's widow, Sherry Crichton, was actually talking to Warner Bros. About doing an official ER reboot.
That's confirmed, yes. But those negotiations fell apart. Sources say the sticking points were money, compensation, and also, significantly, who gets the credit. Proper attribution.
And the estate's argument, their core claim, is that once those talks failed, Warner Bros. Just decided, okay, forget getting permission.
Right. They allege the studio didn't drop the reboot idea. They just tweaked it, changed the settings to the County General in Chicago became a Pittsburgh hospital, gave it a new name, the Pitt, and then just went ahead as if it was a totally original concept.
So they're arguing it was done in bad faith, trying to get the ER magic, the blueprint, without actually paying the price Crichton's contract demanded via that frozen rights clause.
That's the heart of it, yes. The frozen rights clause is the legal weapon here. And you have to understand, clauses like this are really hard to get nowadays.
Right.
They usually belong to creators with immense clout, or who brought truly original IP to the table initially. They were designed specifically to protect the integrity of a franchise, making sure the original creator keeps a hand in, creatively and financially, no matter who technically owns the copyright to the old episodes.
But it's not just that one alleged breach, is it? The lawsuit also mentions a breach of let me get this right, the implied covenant of good faith and fair dealing. That sounds quite serious. What does it mean here?
It's a really important legal concept. It's not just about morals. It's implied in basically every contract. It means neither side can deliberately act to undermine the whole point of the agreement, even if they don't technically violate a specific numbered clause.
Okay, so the point of the frozen rights clause was to give Crichton control over any continuation of ER. If the studio then intentionally rebrands the same project just to sidestep that clause, that would breach this good faith idea.
Exactly. The estate is arguing that promises were made maybe about the created by credit, maybe about involvement, and then pulled back, and then rushing ahead with this thinly disguised version. That violates the spirit, the fair dealing aspect of their original agreement.
So it shifts the argument slightly. It's not just, did you break Rule X, but did you actively try to cheat us out of the benefit of our deal?
Precisely put. And that distinction, it helps explain why this whole thing is framed mainly as breaking the contract, not necessarily as copyright infringement.
Right, because if the studio owns the copyright to the ER episodes, why not just sue them under intellectual property law?
Well, they could try, but the frozen rights clause gives them a much cleaner shot. It's a contractual right that essentially mimics IP control, but it's right there in the contract they both signed. The studio owns the copyright in those specific tapes and scripts, yes, but the contract limits what they can do with that ownership when it comes to making new versions.
Yeah.
It's just a more direct path for the estate.
Makes sense. Okay, let's move to the trickier part, what you called the derivative work showdown. Because even with that strong contract claim, Warner Bros. Isn't just rolling over. They argue the Pitt is different enough to be original.
Correct. And this gets us into the weeds of copyright law itself, even if the main claim is contractual. The central question becomes, is the Pitt substantially similar to ER? Similar in a way that copies protected expression.
And what makes something a derivative work legally?
Basically, it's any work that's based on one or more pre-existing works. Think sequels, translations, adaptations. But critically, for copyright law, it has to copy elements that are unique and protected by the original copyright, not just generic ideas like, say, having doctors in a hospital.
Okay, and the Crichton estate points to the people involved, right? Same producers, same showrunner, even Noah Weil, one of the original ER stars. That feels like strong evidence of a connection.
It certainly suggests intent, which matters for that good faith part of the contract claim we discussed. But for the pure derivative work argument, under copyright, it's more about what's on screen.
And the studio, Warner Bros., points to the differences.
Exactly. They say, look, different city, Pittsburgh, not Chicago. Different characters and a different structure.
Yeah.
Apparently, the Pitt covers one continuous medical shift, whereas ER episodes often span more time. They argue these aren't just cosmetic changes. They make it a new, original show.
But if I'm playing devil's advocate for the studio, lots of medical dramas are fast-paced, use jargon, have trauma scenes. Think Grey's Anatomy or The Good Doctor. Those are genre conventions. How does the estate prove the Pitt copied ER's specific expression and not just the generic medical drama stuff?
That's the absolute crux of the defense for Warner Bros. They need to convince the court that any similarities are just standard for the genre, generic tropes.
Oh, okay.
The estate, on the other hand, needs to show that the Pitt didn't just borrow the idea of a gritty ER, but specific, unique elements of Crichton's expression of that idea. Maybe it's less about the setting itself and more about the visual language.
How so?
Well, ER was famous for its specific style, wasn't it? Those long, continuous Steadicam shots following doctors down hallways, that almost documentary-like chaos, the specific rhythm of the editing.
Right, that kinetic feel.
Exactly. If the Pitt replicates that specific cinematic language, or maybe unique character archetypes that were really central to ER's identity, then the estate's argument gets much stronger. It moves beyond just doctors running to doctors running filmed in this specific ER way.
Got it. So it's about the unique creative choices, not just the basic setup.
Precisely. It's a nuanced fight. But again, that frozen rights clause is so powerful because under the contract, the estate might not even need to prove substantial similarity in the copyright sense. They might just need to show Warner Bros. Made any kind of continuation or derivative work, regardless of how similar it looks, to trigger the clause. It potentially lowers the bar for them.
Let's talk about credit for a minute, because the sources clearly state that the created by credit was a major sticking point when they were trying to negotiate an official reboot. Why is that specific credit so fought over? It's more than just ego or honoring Crichton's memory, right?
Oh, absolutely. It's huge, financially and professionally. That created by credit, it's tied directly to reputation, which in turn drives how much money can be made from licensing this show around the world, residual payments down the line.
Residuals.
And potentially even things like moral rights, depending on the jurisdiction. For an estate managing a huge legacy like Crichton's, keeping that attribution isn't just symbolic. It's about maximizing the ongoing financial value of the entire ER universe. Losing that credit potentially weakens their claim on future earnings from anything related to ER.
So if they had agreed on terms for an official reboot, that credit would have locked in ongoing recognition and, crucially, a financial stake. The fact that the studio allegedly proceeded with the Pitt without that credit is seen as, well, pretty damning evidence of bad faith.
It certainly strengthens that argument, yes. It suggests an attempt to minimize or even erase the original creator's link to the success of this new similar show.
Okay, so given all this back and forth, the contract versus copyright, the credit issue, where does the lawsuit actually stand right now? What's the current status?
The estate's looking quite strong at the moment. The key thing is their lawsuit survived what's called a motion to dismiss.
Which means?
It means the judge looked at their initial claims and said, yes, there's enough here. This is a credible case that deserves to move forward. That's a significant hurdle cleared. So now it's moving into the discovery phase.
Ah, discovery. That's where things often get really interesting. Internal emails, memos.
Exactly. This is where the lawyers get to dig into Warner Bros. Internal communications. They'll be looking for evidence about how the Pitt was developed. Were there discussions about the Crichton deal falling through? Did anyone internally refer to it as the ER reboot? Were they deliberately trying to find ways around that frozen rights clause?
So finding that kind of smoking gun email could be huge for proving the bad faith claim, the breach of that implied covenant.
Absolutely critical. If documents show they were intentionally trying to disguise a continuation to avoid paying Crichton's estate what the contract required, their case becomes incredibly difficult to defend.
And what are the possible outcomes if the estate wins? What are they actually asking for?
Well, they've asked for an injunction, basically, in order to stop the show from being made or aired.
Mm-hmm.
That's a very big ask, often used as leverage.
Right.
More likely outcomes could involve substantial monetary damages being awarded to the estate, or perhaps a settlement, which is common in these cases, that involves a large payout and an agreement to give Michael Crichton the proper credit on the Pitt moving forward, plus potentially a share of future profits.
It really feels like a clash of two eras, doesn't it? You have these older, carefully negotiated creator protections, the frozen rights, hitting up against the modern Hollywood machine's desire to constantly recycle proven IP, sometimes just by giving it a new coat of paint.
It's a perfect illustration of that tension. And honestly, this case is a huge flashing warning light for everyone in the entertainment industry today. For studios, it shows the risks of trying to creatively bypass strong contractual obligations.
And for creators.
For creators, it hammers home how absolutely vital it is to negotiate strong terms up front, especially if you have valuable IP. You need to think beyond just the initial deal. Think about sequels, remakes, spin-offs. Securing rights like frozen rights, controlling credit, that's where the real long-term power lies. Even if the studio technically owns the copyright to the thing you made for them initially, that contract is your shield.
So let's leave our listeners with this thought. What does this all signal for the future? If the Crichton estate wins big here, could this genuinely change how studios approach development? Could it make them pause before launching the next spiritual successor that feels suspiciously like a reboot?
It absolutely could. A major win for the estate, especially based on that frozen rights clause, sends a powerful message. It raises the stakes significantly for trying to reskin existing properties without the original creator's blessing or participation.
So the big question becomes, will the fear of lawsuits like this actually push studios back towards investing more in truly original ideas, rather than constantly looking for ways to cleverly repackage the past? That's certainly something to watch.